Good afternoon, everyone. This is Skylar Carroll, and my partner Evan Farber is on with us. And before we join, I wanted to thank everybody and just give another minute or so while we wait for everybody else to join. Just a reminder, we're using the Zoom webinar platform. Unlike the usual Zoom meeting, you won't be able to unmute your computer or your phone or turn on your video. This is just a webinar. You'll only be able to see us. I hope we don't put you to sleep in doing that, and I hope you're not offended by our hideous faces, but I'm sure you can survive that. Anyway, the presentation will run about 45 to 50 minutes, and we'll have time for questions at the end. We encourage you to put any questions that you might have in the Q&A button, which you'll see at the bottom of your screen. That will allow us to get to your questions as quickly and smoothly as possible. You should have already received the appropriate CLA forms by email, so please follow the directions on filling those out and returning the forms in order to receive CLA credit. Please also look out for the CLE code that will be revealed during the presentation. And then to kick this off, we will start off with introductions. And of course, I did that already for the people who are on already. My name again is Skylar Carroll. I'm a partner at Loeb & Loeb in our restructuring and bankruptcy group. And my partner, Evan Farber, is on. Evan is a partner in our real estate litigation group. And with that, I'm going to turn it over to Evan, who is going to start the presentation for you.
Okay, thank you, Skylar, and welcome everyone to this webinar. And you can go ahead and start on the slides. This is CLE reminders, and now let's start with COVID's initial immediate impact. So as the pandemic begins its third year, in order to appreciate where we are now and where we've been and where we're coming to, it's helpful to begin by looking back to where we started nearly 2 years ago. At the outset of the pandemic, innumerable tenants stopped paying rent. Many of those tenants were literally locked out of their premises, and many had zero income, with a prospect of zero income and zero access to their premises for months to come. Some tenants like grocery stores, pharmacies, and other essential services were still operating. Many were not. Landlords, for their part, were squeezed between these non-paying tenants and the landlord's lenders. Landlords often could not agree to concessions, even if they had wanted to, because their loan documents required lender consent, or because abating or deferring rent could, in the aggregate, cause landlords to breach property performance thresholds in loans. This was a potential silent time bomb for landlords, because even where leases did not otherwise require lender consent, deferring or abating rent could mean that down the road, at certain performance testing dates, the property's performance in relation to the loan could have resulted in the loan going into a cash sweep. So what happened? Well, the widespread belief was that the world would return to normal in just a few months' time. So as a result, many such situations were resolved through short-term rent deferral agreements for periods like 90 days. Other situations did not resolve initially, and so looked like they were headed towards litigation instead. In those instances, landlords and tenants began to dust off arcane lease clauses like force majeure and law school textbook concepts like impossibility of performance and frustration of purpose. But at the same time, as the pressure to get clarity on these issues skyrocketed, it became all but impossible to get any clarity from the court because of various government actions like moratoria on evictions and court closures that made landlord-tenant lawsuits essentially impossible to file or prosecute. So fast forward 2 years, where are we now? I'd like to focus today on a few different aspects of how things have changed. First, the commercial real estate market. Second, the major trends in landlord-tenant litigation. And third, how these changes in the market and in the litigation landscape have impacted other areas such as lease drafting, other interested parties, and the litigation process itself. Next slide. So first, the commercial real estate market. It remains very uneasy, dominated by a profusion of shuttered stores, empty offices, and a continued lack of commuters to fill garages or business travelers to fill hotels. Among the various sectors in the commercial real estate market, a lot of the discussion recently has been around the hospitality industry. While many restaurants, stores, and offices were able to reopen after the initial few months of the pandemic, many hotels remained stuck with 10 to 20% occupancy rates for far longer. As a result, there was significant pressure on the hospitality sector. Many people believe that this was, and perhaps will be, the last sector of real estate to recover, and to some extent may never fully recover. Business travel may never return to close to levels it used to be, so hotels that cater to business travelers may remain hurting indefinitely. I know Skylar will focus a little bit more on the hospitality sector later, but I don't plan to focus today just on that sector alone. Anyone who walks around any downtown will see that office spaces, retail spaces, and even restaurant spaces are also all still hurting. And I'd like to think that my remarks today will be applicable to any of those sectors. Interestingly, the uncertainty in the commercial real estate market has not spilled over to a continuing uncertainty in the legal landscape governing that market. So let's take a look at why and how we got to this point. First of all, as I mentioned, the initial shock of COVID led many landlords and tenants to negotiate short-term rent deferral agreements for periods like 90 days. Turns out, big spoiler alert here, that 90 days wasn't quite long enough to get us past the pandemic. However, that said, for many tenants, it turns out that these rent deferral agreements actually did do their job because they essentially functioned as 90-day bridge loans from their landlords. And those bridge loans helped enough tenants to bridge the gap until the tenants got PPP loans, stores were able to reopen, or other workout arrangements could be made. For those tenants for whom that was not long enough, it was at least long enough to allow them and their landlords to regain their footing and begin longer-term negotiations on a basis that felt less tenuous and less like a tinderbox. So these short-term workouts served a critical purpose at a critical time. 2 years later, of course, these sorts of short-term deals are no longer prevalent. There are certainly longer-term workouts which continue to be negotiated, and we'll talk about that later. Some tenants did not take short-term rent deferrals, but instead decided not to pay rent at all. For some, it was because they were legitimately underwater or forced out of business entirely. For others, including some very large, sophisticated chains, like certain retailers and garages, they realized that there was very little their landlords could do to them immediately. So this was just a conscious decision to either conserve cash at their landlord's expense or improve their leverage for later negotiations. Those were the types of situations that looked most likely to head to litigation. So I will turn to that next. Next slide. Several big picture trends began almost immediately after the pandemic hit, and their effects have continued to ripple through not just commercial real estate litigation, but also into other areas like lease negotiations and other areas of litigation. The first such trend has been widely reported, and with good reason. Landlords, tenants, and their lawyers began focusing like never before on certain lease clauses like force majeure and rent abatement clauses, and legal doctrines like impossibility of performance and frustration of purpose. The doctrines at issue had been very far from the forefront of most people's minds before the pandemic, but in many instances, they were actually settled law and had been for decades, in some cases, in fact, since the 1918 pandemic. But that did not stop numerous parties from trying to test those doctrines anyway. In general, the cases that tested those doctrines during the COVID era resulted in decisions that adhered to that settled law. I'd like to spend a moment surveying these opinions. I should apologize in advance to those of you who are in California, Illinois, or elsewhere, since I will be focusing mostly on cases and statutes from my home jurisdiction of New York. But with one exception, which I will talk about, I believe these trends are reflective of what has happened nationwide. The next slide, we can talk first about force majeure clauses. This sample force majeure clause is from the Redney standard form lease. It's a little blurry, but if you go to the next slide, you can see it in text. These clauses typically provide that while most contractual obligations are excused by force majeure, payment of rent is not. So this clause, for example, provides that the obligation of tenant to pay rent, ... is in no way excused. And courts interpreting this clause have held that, consistent with its language, The force majeure clause in the lease expressly accepts the tenant's obligation to pay rent and additional rent from the scope of the clause. In other words, that obligation still remains. The Times Square photo case from the first apartment that's shown on this slide is a good example of such a case. Some leases do have more expansive rent and rent abatement clauses, and those clauses were scrutinized and tested during the course of the pandemic. Next slide. One clause I litigated during the past year read as an insert to the standard form. And it says, however, if tenant's use of the premises is substantially interfered with for 5 days, rent and additional rent thereafter shall abate until such interference ceases. Owner shall use best efforts to minimize the duration and extent of its disruption of tenant's business activities in the exercise of its rights hereunder. Tenant took the position that the pandemic itself, or the executive orders which required tenant to be out of the premises for more than 5 days during the pandemic, meant that rent and additional rent were abated until tenant was allowed back in the premises in full. Landlord took the position that the second sentence, which talks about the owner's best efforts to minimize, quote, its disruption, meant that this clause applied only to substantial interference caused by the landlord. Since I'm telling you about this case, you can probably imagine that the court sided with my client in this instance. It was the tenant. But they have gone in different directions depending on the language and depending on the case. Next slide. Numerous tenants also relied on the legal doctrines of impossibility and frustration, arguing that their leases were rendered meaningless if they could not actually occupy the space. Courts have generally rejected these arguments and viewed these doctrines very narrowly. For example, in the Gap case and the Times Square photo case, which are both included on this slide, the courts held that the doctrines would not apply because the terms of the leases were longer than the duration of the lockdown order. So tenants would be able to return. And therefore, the purpose of the lease was not frustrated in its entirety, and performance was not entirely impossible. Next slide. The second major trend in real estate litigation over the course of the pandemic was the extreme slowdown of litigation itself. For the first few months of the pandemic, it was essentially impossible to prosecute a landlord-tenant lawsuit because of court closures, as well as executive orders and other government action, such as moratoria on evictions, as I mentioned earlier. As the pandemic began to stretch past the initial few months, the courts began to reopen, and the moratoria were largely limited to residential assets. Cases could be filed again, but that was not a panacea. The courts now had a backlog, and like everyone else, they were working remotely and often short-staffed, so they were operating on very significant delays. Now, I should hasten to add here that I do not mean at all to disparage the courts in the slightest. They deal heroically with an extraordinarily high volume of work under very difficult circumstances. But the result is that even in the best of times, litigation is not necessarily known for speed and efficiency. So during the pandemic, even more so. Litigants expected court delays that were often simply immense and also often very hard to predict. So these two trends, first, a focus on force majeure and related clauses and doctrines, and second, the slowdown of litigation, were very significant trends by themselves. But they also had a number of significant repercussions which wind their way through the rest of my talk today. Next slide. First, these delays strongly incentivized rational, pragmatic business people to try to achieve quick business resolutions reasonably instead. And this makes sense. The landlord-tenant relationship is the quintessential long-term, mutually beneficial business relationship. Certainly as compared to many other types of litigation, it's much less common to have landlord-tenant decisions driven by anger or passion or by anything other than the most sensible business resolution. And since well over 95% of lawsuits settle sooner or later anyway, most landlords and tenants figured, why not cut that time short, save the acrimony, and reach a deal sooner rather than later. That is not at all to say that landlord-tenant litigation wasn't or isn't being fought at all. It was, it is, and it ever shall be. And in fact, during the pandemic, the levels of litigation in this area did in fact rise. But they didn't rise quite as steeply as expected. It wasn't quite as frenzied as many people anticipated. Next slide. The second impact of these changes was in the substance of these negotiated resolutions. Lease drafting has changed. The trend towards negotiated resolutions and the trend towards accepting settled law regarding force majeure and other contractual clauses and doctrines have not at all surprisingly meant that lawyers and principals who are drafting lease amendments and new leases are also focused on these clauses like never before. Next slide. Much more detailed force majeure clauses are including language that explicitly waives or permits COVID-related defenses. In some cases, where tenants have greater bargaining power, much more detailed rent abatement clauses spell out in much greater detail what rights tenants might have with respect to non-payment or deferral of rent. Data published by Law 360 in mid-2021 showed that the use of rent abatement clauses in commercial leases had jumped by nearly 50%, as had the use of force majeure clauses covering pandemics or pandemic-related events. In other words, these may have been boilerplate clauses before, but they were certainly heavily negotiated and not boilerplate now. The other point here is that even though the short-term rent deferral agreements are no longer prevalent, rent deferral clauses in longer-term lease amendments remain part of the landscape in many instances. Next slide. And I think I had just included the text in case that prior slide was blurry as well, but it looks like it's fine, so we can go on to the next slide. Other clauses focus on other aspects of the COVID experience. For example, some leases include clauses expressly providing that any COVID-related benefits a tenant may receive, whether government benefits, insurance benefits, or the like, must offset any rent reductions or rent deferrals. This is a sample of such a benefits clause that we've seen. Next slide. Another way that the landscape has changed is that some of the focus has shifted from lawsuits between landlords and tenants to lawsuits involving other interested parties. This is, to some degree, the flip side of the milder than expected rise in landlord-tenant litigation. To some degree, it's just a matter of common sense. As landlords and tenants decide it's not worth fighting with each other, they start to look for other sources of cash to make up any shortfalls. Tenants will sometimes try to pass on their losses to their insurers. And where tenants are not paying, the landlords are pursuing claims against others, like guarantors, or trying to pass on the losses to their lenders. Because these sorts of disputes tend to be less similar to each other than standard lease disputes, it's not as natural for other similarly situated cases to fall into line once the first few initial decisions are rendered. As a result, there is still a greater feeling of uncertainty, which continues to fuel these cases, at least as contrasted with the landlord-tenant cases. Let's take a few examples. Next slide. First example is guarantors. In May of 2020, New York City amended its administrative code to provide that personal guarantees of commercial leases, quote, shall not be enforceable if the tenant, one, was required to close because of certain executive orders issued in March 2020, and then two, defaulted on its lease between March 2020 and March 2021. Next slide. This provision came under significant scrutiny almost from the start, with many people predicting that it would likely be struck down as unconstitutional. It was a taking or a violation of a private contract. But New York state courts have generally upheld this provision. A few sample cases are on this slide. By contrast, the Second Circuit has expressed significant concerns about the constitutionality of this statute. Next slide. In the case of Melendez versus City of New York, which was decided in October, in a very lengthy opinion, the Second Circuit held that the law's constitutionality was questionable. Applying the three-part test used under the Contracts Clause of the U.S. Constitution, the circuit held first that this law, quote, substantially undermines the landlord's contractual bargain, interferes with his reasonable expectations, and prevents him from safeguarding or ever reinstating rights to which he was entitled. Second, It held that the record, quote, plausibly suggests a significant and legitimate purpose for the guarantee law, which was to ensure functioning neighborhoods. Third, however, the circuit pointed to a number of aspects of this law, including the fact that the relief it offered was permanent, that it was not conditioned on a showing of need or on a showing that the tenant had reopened its business, and that it failed to provide compensation to landlords, among other things. And the circuit held that these features of the law weighed heavily against the conclusion that the guarantee law is a reasonable and appropriate means to serve the city's professed public purpose. Ultimately, the Second Circuit remanded to allow the parties to develop the record further, so we can expect future litigation in the Second Circuit and perhaps up to the Supreme Court on this issue as well. Next slide. Another example of litigation that spreads beyond landlords and tenants relates to insurers. Tenants have pursued insurance claims for pandemic-related losses, often based on business interruption policies, which often requires a showing of physical damage or physical loss. This is one area where New York courts may diverge from courts elsewhere in the country. The Second Circuit and the New York State courts have repeatedly, and as far as I can tell, unanimously rejected such insurance claims, holding that neither the virus itself nor the executive orders constitute a physical damage or physical loss. By contrast, the New York State courts have acknowledged contrary decisions from other jurisdictions around the country, including California, Illinois, New Jersey, Florida, Missouri, I think Alabama, Connecticut, and elsewhere. For example, in King Gray Insurance versus Farmers Group, the Central District of California held that there could be a difference between physical damage and physical loss, and a loss of the use of property could be a physical loss. Similarly, in Valley Lodge Corp versus Society Insurance, the Northern District of Illinois held that it was a reasonable question to put to a jury whether there was a causation or whether there was a physical loss. And then there's not as much unanimity. There are cases that go in the other direction elsewhere in the country, but New York seems to be unanimously closing the door in the face of these types of claims, which is not true elsewhere. Next slide. Finally, the litigation process itself has changed too, but in some respects, not as much as might have been expected, or perhaps not at least on a permanent basis. So the litigants and courts are all trying to find ways to reduce the backlog and cut down the delays associated with each case. Courts, for their part, are pushing mediation like never before. Over the years, well before the pandemic, courts have increasingly started pushing mediation as a way of getting cases out of their system and getting cases resolved more quickly. And these efforts have increased dramatically since COVID. Courts are pushing mediation at virtually every turn, at the outset of the case, before and after motion practice, before and during discovery, before trial, even pending appeal. This is true of all litigations, but in the commercial real estate context in particular, because the parties tend to approach things in a more business-oriented manner than most, this often opens the door to more fruitful discussions among the parties. One interesting surprise is that the pandemic and the associated court delays have not really shifted more cases from litigation to arbitration, which often has the potential to proceed much faster than litigation. In private arbitration, you don't need to worry about the court delays. You go at the pace set by the parties and the arbitrator. There are long-standing and good reasons, though, that real estate litigation tends to use the court system rather than private arbitration. For example, the need to record public documents, and landlords need to use the threat of eviction as a backstop, which often impels parties towards a public forum. In addition, arbitration requires an agreement of the parties, and often one party is less interested in a quick resolution. So unless there's already an arbitration agreement in the lease itself, it may be hard to get agreement at the time of the dispute. And very few leases have arbitration clauses already in them for the reasons I just mentioned. But there are ways to siphon off certain lease disputes, like payment disputes in the absence of any termination. And it's possible to include arbitration language governing those. But anecdotally, there have been very few leases, whether new or amended, that try that effort or use such language. Many lawyers are trying other creative methods of short-circuiting the delays. One primary example is what seems to be a sharp uptick in pre-discovery motions for summary judgment. Lawyers have traditionally viewed these pre-discovery motions as somewhat risky devices. But faced with clients who are looking for quicker action, lawyers have now warmed to these early summary judgment motions as a way to get their key legal issues before the court at a far earlier stage in the case than they might otherwise have been able to do. In addition, many of the workouts that have been negotiated over the last 2 years have also been backed by confessions of judgment, promissory notes, or similar devices intended to enable very quick resolutions if a subsequent dispute should arise. These devices commonly provide that if a tenant fails to pay again, the landlord, probably after a notice to cure period, can skip past the litigation process, perhaps entirely, and obtain a judgment quickly, and often on a minimal showing. These are very powerful devices, and tenants are often very reluctant to sign them. But, as always, it often comes down to a question of leverage. And perhaps that's one way in which commercial real estate really hasn't changed very much at all. Before I turn it over to Skylar, let me just say one other thing, which I know is very important to many of you. Next slide, and it's the CLE code. It's up on the screen now, and I'll read it out loud. CLB 028. And CLB, cherry, lemon, banana, 028. Thank you very much. And now, to take this CLE from good to great, here's Skylar.
Thank you, Evan. And I'll just start with one comment on the last comment that Evan made, which was leverage. A bankruptcy filing is often an attempt to change the playing field and increase the leverage of usually the borrower or the tenant that files bankruptcy. Usually it comes after some indication, either in negotiation or litigation, that things are not going their way. The difference in bankruptcy is oftentimes the borrower / debtor, once they file, is dealing with dozens, hundreds, or even thousands of constituents that they are opposing. And just to give a simple example of the two opposites, you have a single asset real estate case where it's really just a two-party dispute. You have the borrower and the lender. And then the other side of the coin is what we're seeing quite often now in bankruptcy, companies that are filing because they are targets of mass tort litigation, like the opioid companies, like the asbestos cases that have been around for a long time, like the talc companies. I'm sure many of you have seen in the news recent discussions of the Sackler, Purdue Pharma, the J&J bankruptcies that are proceeding. But just a quick side note there, and I'll come back to what I have on my slide, which is what we've seen during the pandemic. At the beginning of the pandemic, there was a huge uptick in filings. Quite often, these were filings by well-known companies, such as Lord & Taylor, JCPenney, CBL and Associates, Neiman Marcus. And we saw that from right around March of 2020 until the end of the summer. After that, things actually turned the other way. Good news for most people, the non-bankruptcy folks out there. Overall filings since the end of last summer, 2020 summer, have been down significantly, so much so that the filings in 2021 were at the lowest level since the bankruptcy code was enacted in 1978. The bad news, however, for the folks on this webinar is that real estate cases dominated the largest filings. In fact, out of the 9 largest bankruptcy filings, 4 of them were real estate cases. Next slide, please. Before I get into some of the issues and the litigation that we've seen, I'm going to talk very briefly about the structure that we most often see, and particularly in bankruptcy cases. as many of you know, the typical borrower now is set up as a special purpose entity, special purpose vehicle, SPE, SPV, and is required to be structured as a CMBS, commercial mortgage-backed security, loan would be, which requires separateness covenants, requires the entity to be, quote, bankruptcy remote. And a lot of those structures are set up to avoid bankruptcy, among other things. One thing that's important to realize, though, is that does not make the borrower bankruptcy proof. The idea really is to limit the potential that a bankruptcy will be filed, and the potential that if a bankruptcy is in fact filed, the lender will have limited negative effects. Doesn't mean that a bankruptcy won't be filed or can't be filed. And there are two parts to that. The first being that the structure themselves, in almost every case, cannot ever guarantee a bankruptcy won't be filed, even if everything is properly documented in the loan documents and the organizational documents, and properly followed in the operation of the borrower and the lender and its other relationships. But the second part is that borrowers, especially those that file bankruptcy, don't always abide by their agreements. I'm sure that'll shock you, but sometimes borrowers who file bankruptcy don't actually do what they're supposed to. And the way these structures are set up, they are not foolproof if the borrower breaches their obligations. Next slide, please. To get into a little bit of the detail, I'm not going to take very long on this, but the bankruptcy remote and separateness generally requires a couple of things. The organizational documents are set up, again, as a single purpose entity with covenants that require the borrower to act in a certain way. Generally, those are to only have true arm's length dealings with other companies, even if they are affiliated entities, and to act separately from those entities, again, even if they are affiliated entities. The single purpose entity, as its name implies, can only have a single purpose, i.e., owning and operating the property that it owns and which usually the lender has obtained a mortgage on. Generally, these loans require an opinion letter, sometimes referred to as a bankruptcy remote opinion or a non-consolidation opinion. And generally, the purpose of that is to ensure that if the borrower acts in the way required by the loan documents and the organizational documents, the borrower will not be consolidated with another entity. Let me take a quick step back there and explain what that means, because the purpose is to ensure that even if there is a bankruptcy filing, the lender will not be harmed. The bankruptcy parlance, the lender won't be crammed down, forced to take a new mortgage or an extension of a mortgage that they don't consent to. And one example will help there. Many of you will remember the mall operator General Growth Properties. They filed bankruptcy after the 2008 financial crisis, and they had a provision, which I'll talk about in a minute, requiring an independent director. Despite that, the company filed bankruptcy, and GGP itself was a large operating entity with numerous special purpose entities that it owned and operated. And the lenders objected to the filing, moved to dismiss the filing, and the court said, no, you are permitted to file bankruptcy, but that doesn't mean that those entities are going to be consolidated. And that is where the courts, where the bankruptcy code really gives leverage to borrowers to cram down a lender. More on that in a minute, but one of the things I was just talking about is what's referred to often as golden shares. And that is an equity interest that gives its holder certain blocking rights, which often includes the right to block a company's bankruptcy filing. It has to be done through the organizational documents. It's not enough to put it in the loan documents. And typically it's granted to a lender. What the purpose of that is to avoid a bankruptcy filing, because the idea is if the bankruptcy filing cannot be authorized without the lender's approval, it's unlikely the lender is going to do that. One of the problems with that type of a provision, however, is borrowers sometimes argue that the lender's refusal to consent to a bankruptcy filing is improper and bring a lender liability lawsuit. As a result, another form has been created, the appointment of an independent director. And typically that would be appointed by the lender or the creditor who is trying to stop the bankruptcy filing. And back to GGP, that's actually what happened in the GGP case. The lender had appointed an independent director. Some years later, when GGP ran into financial problems, they looked at the organizational documents, and the organizational documents allowed them to terminate the existing independent director and bring in someone else. And they brought in a person, actually more than one person, who was in fact totally independent, had no relationship with GGP or any of its creditors or equity holders. And GGP laid out the position, their circumstances, and said, here's why we need to file bankruptcy. And GGP was able to persuade the independent directors that filing bankruptcy was in fact the right thing to do. So, as I mentioned earlier, the lenders came in and said, hey, wait a second, this isn't what we bargained for. We were supposed to be guaranteed not a bankruptcy. Well, the bankruptcy court said, no, that's not what you bargained for. And if you look at the documents, which of course you imposed on the borrowers, it doesn't prevent that. GGP did exactly what they were permitted to do under the loan documents and under the organizational documents. So obviously the court did not dismiss the bankruptcy court. On to the next slide, please. Here's another case which discussed the issues of golden share agreements. And this is in INRI 3P Hightstown, a New Jersey decision from 2021. In that case, the court actually did dismiss the Chapter 11 case. It was filed by an LLC because the operating agreement precluded the bankruptcy filing without the consent of the preferred membership interest. In this case, it was a little different, however. It was not a lender who was granted those rights, but it was a member of the LLC. And so the court viewed it a little bit differently. Here, the court went through the analysis.
I think we lost Skylar for a second. Let's give him a moment to see if he can come back.
Filing was appropriate.
There we go.
The court then said what does public policy say? And the court said there's a couple of different issues to look at. First, parties should have the right to reach an agreement on anything they want. But the right to file bankruptcy is an important right that is actually in the Constitution. So that may override in certain circumstances the parties' rights. In this case, however, the court said no, it didn't. The court also looked at fiduciary duties and looked and considered, is a bankruptcy filing the best outcome for all the stakeholders? And the court said that in general, a bankruptcy filing would allow the parties to be on equal playing fields and be in one place with their dispute resolved. But that wasn't the only issue. The fact that the parties had agreed on restrictions to bankruptcy was in some ways a limiting factor to the court's fiduciary duty analysis. And I think the most important limitation on the fiduciary duty analysis was that this was a Delaware LLC, and Delaware law allows for provisions which restrict or in fact eliminate the fiduciary duties of directors and, in the case of LLCs, members. I think that was an important consideration for the court in this case. Next slide, please. Next, we have a case called Pace Industries, which was decided by the Delaware Bankruptcy Court, Judge Walrath, who, for those of you who are really bored and want to know something about bankruptcy, Judge Walrath has been on the bench longer than any of the other Delaware judges. And in this case, she held that because of the specific facts and the circumstances of the case, the blocking right that the party tried to execute was not appropriate and had the effect of restricting the debtor's constitutional right to file bankruptcy. As a result, Judge Walrath held the restriction was void as against public policy. And again, I think another factor in the decision here was that the judge was not exactly comfortable with determining that the party exercising the rights was just a creditor. They're also given substantial equity rights. And I think that colored her decision too. Judge Walrath did go out of her way to make clear that her decision was based on the specific facts and circumstances of the case. But as we see in opposite of Hightstown, and there are lots of other cases before these recent ones, there are other cases which uphold restrictions like this. So the Pace decision really deepens the divide between courts that determine under public policy these rights are not appropriate and the courts that enforce contractual rights. It also again highlights that Delaware may be the preferred jurisdiction for debtors to file bankruptcy. Next slide, please. And here we have another decision. Sorry, one more. There you go, thank you. Here we have another decision by Judge Walrath issued last year in PWM Management, where she again found the exercise of the blocking right was not valid under the circumstances. In this case, again, this was a creditor who, this was an equity holder who was given certain rights that were really, as Judge Walrath determined, really more like debt, even though it was called equity. And this is something that you see in bankruptcy quite often. You may have heard of the term recharacterization. It's not unusual for courts to look at debt or equity and determine that you may have called it one or the other, but in fact, it really should be the other. So I'm ruling on that. And Judge Walrath noted that in her decision as an important factor. Next slide, please. And next, I'm going to talk a little bit about owners and tenants issues. I know Evan talked about them quite a lot in the litigation context. First, I want to talk more broadly. Owners' problems during the pandemic, many of you will know these and they're obvious. Their tenants defaulted and they filed bankruptcy. Many of their tenants closed. This was particularly true with retailers and restaurants, resulting in the inability to collect rent. Another problem was that tenants weren't paying rent, they weren't operating, but they were still continuing to occupy the space. In most instances, that wasn't a big deal because landlords didn't really have new tenants to come in and occupy them. But in some bankruptcy cases, that actually was not at the very beginning of the pandemic, but soon after, that was something that was happening because there were some companies that set up specifically to take over in malls and other retail spots where landlords were just looking to get foot traffic. And so some landlords had tenants they wanted to get out because they had new tenants to bring in, but they obviously couldn't, and they couldn't collect rent. Next slide, please. Here, I want to talk a little bit about bankruptcy and what happens with a tenant. As you probably know, if you are a tenant under a lease that files bankruptcy, before the end of the bankruptcy case, you either have to assume or reject the lease. Assume means that you accept the terms of the lease and agree to abide by them going forward. It also means that the debtor tenant is required to cure all the defaults under the lease. And typically in the pandemic, that was payment of back rent. Problem with that is very few tenants had the ability to pay back rent emerging from bankruptcy. I'll just give you one example. In the Neiman Marcus case, they had a whole bunch of leases that had expensive rent that had not been paid for many months since the beginning of the pandemic. Neiman Marcus was able to emerge relatively quickly from bankruptcy, but one of the biggest problems they had was they had stores that they wanted to stay in, and they didn't have the ability to make the cure payments. This resulted in substantial negotiations, and in some cases, a whole lot of bluffing. There were some tenants, and Neiman Marcus probably was one of them, that really had the ability, did not have the ability to make the payments that were required and negotiated with their landlords. Other tenants, however, may not have been as forthright and may have been forcing the issue just to get a reduction. And landlords really didn't know who was who. Many of the smart landlords would dig in to the tenants' financials, and many of the landlords that I've seen actually have folks who understand tenants' cash flows and understand these types of situations and are able to guide them through this. The other side of the coin is lease rejection. That is essentially like a breach of contract. The tenant has to leave and moves to, loses the space and gets out. The landlord is then entitled to take back the space, generally entitled to keep a security deposit or whatever other benefits they have under the lease. Next slide, please. This one really just wanted to highlight the fact that many of the arguments Evan referred to in the litigation were also playing out during bankruptcy cases. There were a number of tenants that filed bankruptcy and made the same argument that they shouldn't have to pay rent. But in bankruptcy, they also did it in a couple of other ways. One of them was called a procedures order. And there were a number of retail tenants that had many leases that filed a motion on the beginning of their case saying, although the bankruptcy code requires the payment of rent, we would like to not pay rent for the first few months And so we're not going to pay rent. And if a landlord wants to object, they can't do so until X period of time. Most of them were 60 or 90 days. And at the end of that time, they have to make a motion. Obviously, these were objected to by a lot of landlords, but some of the bankruptcy courts actually granted this type of relief. Next slide, please. Talk about the CARES Act, which was enacted. Again, just want to hit on this generally. It extended the debt limit to $7.5 million for small business debtors. And generally, that's a pretty low number, but there are a number of debts that are excluded. For example, contingent debt, like the rent that would be due into the future, was excluded. Other things like unliquidated debts, where you might have a litigation claim or some other disputed debt, that could mean a company with significant assets and liabilities could take advantage of the Small Business Act. And in fact, did. One notable case was Sizzler, the restaurant chain, where they filed as a small business debtor, even though they had about 75 locations at the time, because the $7.5 million limit is judged individually by each debtor. There are a number of benefits, like an extension of the time to pay rent. You don't have to you don't have to pay rent at the initial filing when you have a small business case, and you're entitled to extend that as well. Next slide, please. Here I want to talk about a couple of the Chapter 11 cases we saw during the pandemic. One in the hotel industry, as obviously we all saw, there were lots of problems in there. And one interesting case was EHT, Eagle Hospitality. It owned about 18 hotels, and including the Queen Mary. It had an interesting structure. It owned the hotels, but did not operate the hotels. The operator entity was managed by two individuals who were later referred to in a published decision by Judge Sanchi of the Delaware Bankruptcy Court as fraudsters. They did some bad things, such as getting a fraudulent PPP loan and taking the money themselves. The entities were set up in addition to have each entity level a mortgage as the owner, and then there was debt on the overall owner of each of those individual property level entities, generally referred to as a holdco, propco type of structure. These companies had problems before the pandemic. And one note there were a lot of businesses that filed after the pandemic who really had problems before and used it as an excuse. And once they filed, next slide, please, there were a bunch of issues. One that was particularly interesting was the significant lender, which had a loan to the holding company, did not have a lien on the assets of each individual owner. They only had a lien on the assets of the holding company, which only owned the stock. As a result, their lien in bankruptcy really was only worth as much as the equity of any of those propcos. In this instance, each of those was in bankruptcy. Almost all of them were underwater, so there really wasn't much left there at all for the lender. So the lender essentially had a 100% deficiency, or in bankruptcy terms, unsecured claim, resulted in the beginning of litigation between the unsecured creditors, who said, wait a second, the lender shouldn't get anything more than the unsecured creditors. As often happens in bankruptcy, the parties ultimately agreed. One more note on the principals of the company. They were ousted before the bankruptcy but not before they were able to steal the proceeds of the PPP loan. They were sued during the bankruptcy. As I mentioned, Judge Sanchi determined they were fraudsters. He issued an opinion, he issued sanctions, and he issued an order that said they were to determine what these specific sanctions were, including potential arrest. Before that happened, however, one of the principals filed his own Chapter 7 bankruptcy. So we'll see what happens next there. Next slide, please. Another bankruptcy case of a hotel owner, PW Property Management, which is an owner of two large commercial office buildings in New York and Chicago. In this case, the property manager filed a motion to dismiss that was denied. The part of their motion was to say that their Chapter 11 filing was really motivated by an improper attempt to reject the management agreement. The court held that the case should not be dismissed, but did not yet determine the issues of rejection. There's also a litigation between the debtor and Wells Fargo, who the debtor says will prior to the bankruptcy improperly debited their account, and that one is ongoing now as well. A couple other cases just to very quickly highlight at the end here. Next slide, please. CBL, mall operator, as I briefly referred to. This was a bankruptcy to essentially do a balance sheet restructuring, convert most of the debt to equity. The bankruptcy was filed with what's called an RSA, a restructuring support agreement, in which most of the bondholders agreed, but the bank lenders had not yet agreed. So there was litigation. The RSA was amended multiple times during the Chapter 11, ultimately resulting in an agreement that led to confirmation of the plan. One of the debtors, though, Laredo, was the subject of a motion to dismiss, which in that case, the lender said it shouldn't have been part of the overall case because all of the parties agreed those assets needed to be sold. After mediation, they agreed, they reached an agreement which dismissed the Chapter 11 case, and despite what the lender had said, did not sell the asset, but extended the loan for 2 more years. The next slide, please. Washington Prime Group, very similar, an RSA, in this case, providing for a dual track plan, which was they pursued a restructuring. They also at the same time pursued a sale of all the assets. And ultimately, they determined that restructuring was the best way to go forward here. Next slide, please. Hospitality Investors Trust, another hotel operator, very similar debt for equity swap. And the last slide, please. Just one issue that I want to highlight, not really a real estate issue per se, but a really big issue that's being litigated now is third-party releases, primarily for directors and officers and shareholders. We saw this in the Purdue Pharma case, the Sacklers. We see it in the Ann Taylor case. And in both of those cases, the bankruptcy court confirmed plans which provided for releases, but in both of those cases, the releases were reversed on appeal. And in the Purdue Pharma case, the district court judge issued a 100+ page decision explaining why bankruptcy courts are not permitted to grant releases like this. In the Ann Taylor case, the decision was not as lengthy, but it was really angry. The judge made very clear that he thought the bankruptcy court was abusing its discretion and that he was not going to permit these types of things to happen. And with that, next slide, please. Wanted to thank everyone for attending, and hopefully we still have a couple minutes left if we have any questions. I don't see any questions. So Evan, is there anything else you want to add?
I don't see any questions either. It's been a pleasure doing this with you, Skylar, and I hope this was helpful and informative to everyone who's participated. I'll read the CLE code once more. It's CLB028. And if there are any other questions, feel free to put them in the chat now. We can stay on for 30 seconds or so. I see a hand raised.
Evan, I do see one question that is probably one for you here. And of course, since I don't know how to use tech, it just disappeared. Here you go. Are you seeing any trends of lawsuits leaning towards tenants?
So yeah, that is a great question. Not really. I think what we're seeing is that lawsuits, well, let me put it this way, decided opinions still lean heavily towards landlords, and perhaps because of the issues that tend to be focused on, like force majeure or others, which are generally already settled law that usually favors landlords. I'd say with decided opinions, the trend is pretty much favorable to landlords. But what we will see is courts that will try hard not to reach the stage of a decided opinion, that will try hard to push the parties towards a settlement so that the tenant can be treated a little bit more favorably, and try to push things in what the courts presumably view as a more equitable manner. And certainly that the trend that I talked about earlier about trying to resolve cases up front is part of that. So I think before we get to the stage of the decided opinions, we see courts trying to, off the record, push things a little bit more favorably towards tenants.
And that is definitely something you see in bankruptcy cases as well. Looks like one more message, but I don't see it as a question.
Not a question. Are there any others? We can stick around a little bit longer.
Okay, well, thank you, everybody. We appreciate it. And certainly you know where to find us if you do have any questions.
That's right. Thank you very much.